Hi, Kai Rosga here. Welcome back to the weekly wrap-up brought to you by Decoded.com. Every week I try to give you the latest developments in tech regulations, and this week I'll cover Amazon with two developments. One, a Wall Street Journal report regarding additional claims of disadvantaging third-party sellers, and two, some DOJ indictments that involved some former Amazon employees. I'll also cover a sneak peek of the, quote, antitrust case of the century against Google that's forming with the DOJ in some states. And I'll round out the week's discussion with an update on the Google Fitbit deal, which is being reviewed in Europe. Just a reminder that the views here expressed are my own, and none of this should be seen as legal advice. So let's start with Amazon. As a refresher, the Wall Street Journal had previously reported on Amazon's alleged use of seller data to advantage the launch or pricing of its own private label products. This led to some exhaustive questioning on the topic during the congressional hearings, during which the CEO of Amazon, Jeff Bezos, testified. And that hearing raised a lot of issues concerning how third-party sellers are treated on the platform, especially when they offer products that may compete with products offered by Amazon. This week, another Wall Street Journal report came out alleging some additional claims like that. Specifically, the report indicates that Amazon had taken steps to make it more difficult for device makers to buy keyword searches for searches that are conducted on Amazon.com when a customer is looking for a product. This affected devices that compete with Amazon's, so that would include some smart speakers, video doorbells, streaming TV boxes, and things like that. And specifically, the claims are that Amazon had prevented some of those rival device makers from buying keywords for Amazon's products. So specifically, a rival device maker would be prevented from paying to appear in response to someone who searches Amazon for an Amazon product. This restriction applied to only, quote, tier one competitors, and so smaller rivals were not restricted in this way. And it should be noted also that it's not an uncommon thing to buy keyword searches for a rival's search terms. This is sort of a lucrative part of Amazon's business and other search-based businesses online as well. Other claims in the report included that Amazon had downgraded the positioning of rivals in the search results that would come up, meaning that those search results would appear below Amazon's own products. And lastly, in some cases, there might have been even an outright ban of the sale of certain products that rivaled Amazon's. So, quick takeaways here. The tactics here draw some parallels to the search bias investigations of Google, which we'll sort of come back to in a second. This should all be thought of in the context of the FTC's ongoing investigation of Amazon, where the sort of fair treatment of third-party sellers is being looked at as a potential antitrust issue, especially where it might affect sellers that compete with Amazon. And lastly, we shouldn't forget the congressional hearings, and the fact that the reports will be coming out from those hearings soon. And so the allegations in the Wall Street Journal report are likely to figure into those reports as well. In other Amazon news, the Department of Justice laid down some indictments, grand jury indictments, of 6 individuals who are accused of bribing Amazon employees. These 6 individuals are third-party sellers that use Amazon. 2 of them are former Amazon employees. And the allegations in the indictment, or the charges in the indictment, are that these individuals paid Amazon insiders to reinstate listings that had been blocked or banned by Amazon due to safety concerns, counterfeiting concerns, or use of fake reviews. And further, the charges include that the employees paid to get information about their competing third-party sellers, which they can then use as competitive intelligence. They also got information about Amazon's algorithms, which they could then use to develop strategies for flooding their competitors with fake negative reviews. And they even managed to get some competitors' accounts suspended. The takeaway here is competition can easily bleed into criminal allegations. Here it's bribery and fraud and related charges. But antitrust compliance and competition-related compliance can easily spiral into other claims. On to Google. The ongoing U.S. investigation of Google is close to seeing some initial complaints filed. As a refresher, the DOJ and several state attorneys general are conducting antitrust investigations of Google. FTC is also conducting an investigation, but it's a look back of prior tech acquisitions of Google as well as other big tech companies. Reports are indicating that the DOJ is now going forward with filing an antitrust complaint against Google. However, it will be a narrow complaint involving just the search business. In particular, the reports indicate that the complaint will involve tactics that Google has used to become the default search engine on devices such as the Apple iPhone, which the claims would likely include that this excluded rival browsers from being able to compete. Other claims may be added to that complaint later this year. And in the meantime, the state attorneys general, which are also conducting an investigation, appear to be on track to file their own separate lawsuit, which would involve the online advertising business of Google, in particular, its dominance and actions in the various chains of what's called the ad stack of the online advertising business. This investigation has been led by the Texas Attorney General, but it looks like the DOJ is expected to at least join that lawsuit as a co-plaintiff. And in addition to that complaint, there may be another series of complaints filed by states involving search bias or self-preferencing allegations, which have to do with Google advantaging its own vertical products or services in the search results that appear when people use Google search. So this will be akin to the allegations at the root of the EC's current fine of Google, as well as a prior FTC investigation, which included search bias that was closed several years back. So the net here is a convoluted path forward in the U.S. antitrust investigations against Google. It looks like there might be staged complaints by the DOJ, separate complaints by state attorneys general, and let's not forget the FTC, which is doing its retrospective analysis of prior Google acquisitions, which could also figure into some of these other allegations as well. This, of course, makes for not only an unpredictable climate here for Google, but also it likely will result in some tensions or crossfire to have all these different plaintiffs filing claims in different fora, raising different claims, which overlap factually and legally, and each representing unique or different constituencies, including political influence. So it is going to be a long journey here once these lawsuits start coming down. How it ends is impossible to predict at this point, but it will take a long time. If prior examples are to be drawn from, like the Microsoft investigation, we should expect this to drag on and take a lot of swerves along the way, and possibly, more likely than not, result in a settled outcome as opposed to a trial. But again, difficult to tell now how things will play out. We'll have to wait and see how those complaints are filed and and what they allege specifically. And finally, in additional Google news, Google is still navigating the regulatory process in Europe to get its acquisition of Fitbit cleared. Google has been seeking to acquire the fitness wearables maker, and as part of that process, had offered some remedies to the European Commission to alleviate some concerns that it had raised during an initial review. And those proposed remedies included Google committing to not use health data collected by Fitbit in the targeting of ads on other parts of the Google business. So, for example, in its general search. The European Commission had received public comments on those proposed remedies, and it ultimately decided to open a full-blown phase 2 investigation of antitrust concerns. Reports indicate that the initial requests for information that had been sent during the phase 2 investigation, the responses are now coming in. Those RFIs have targeted sort of the two main issues flagged in the announcement of the phase 2 investigation, mainly the risk that Google could degrade the interoperability of the fitness smartwatches with the Android operating system, which is a Google operating system that runs on smartphones. And there the theory would be that this would be an attempt to foreclose competing wearable rivals from an important smartphone platform. And then the second topic covered by the RFIs is the sort of value of the Fitbit data that Google will acquire in the transaction, and specifically whether the acquisition gives Google some sort of data advantage that would put up a barrier to competitors of Google in advertising, from being able to, for example, better personalize and target ads. So that's the EC investigation. The deadline for a decision has been extended to December 23rd. So it looks like it will be a difficult run-up to the holiday week for people at the European Commission, as well as those defending Google and Fitbit. And so we'll have to wait and see what happens. That's it for this week. Thanks for watching. For more on the latest in the efforts to regulate the digital revolution, check out my website, techlawdecoded.com, or follow me on Twitter @KaiRozga. Have a good weekend, and hopefully see you next week.